Hello and welcome back to section 5. This is the last part of our class. Today what I'm going to review with you are leases and some of the things regarding insurance. So let's get started. All right, with regards to leases, um, there are different requirements and rules. One of the things that I'm going to encourage you to get is from our Attorney General's office. You can go and download this book. It's called Landlord and Tenants' Rights and Responsibilities. So it's a free publication. You can get a hard copy or you can get it in a PDF under the publications from the Attorney General's website. And the nice thing about it is it goes over all the statutes, the rules, other resources that are available. And there is no one standard lease. Instead, there are statutes and rules, and then leases are created from that. So you can get them from different places. You can get them from the Minnesota Housing Association, or Minnesota Multi-Housing Association, which I'm a member. If you join, you'll get a magazine every month. In addition, you'll be a member, and so then you can get a discount on some of their forms, their leases, and other things. And then they have investor meetings as well. So they have a lot of good resources over there. I would highly endorse you becoming a member. It's graduated in price based on the number of units that you own. So like under 10 units, I think it's $160 a year. And they're the ones that are the advocacy for you, the landlord, with regards to fairness and taxation and other things that occur in the state legislature. So I think they're a great organization, highly endorse them. If you get the booklet from the Attorney General's office and you page through it, what you'll quickly realize is that there are lots of rules for the landlord, but there really aren't any rules for the tenants. Instead, there's tenant advocacy groups, but there is no landlord advocacy group that's free. You have to pay an attorney or get some form of a legal plan or join the organization, but there are lots of resources for tenants. So I know you want to run your business 100% according to the law, and I would encourage you to do that because there are all of these advocacy groups out there that are tenant centric, that will make sure that if there's a complaint filed against you, that you are following the rules. So don't just assume that you cannot do something and it's going to be okay. There are rules specifically that you do need to follow. Now, one nice thing that I like about the Minnesota Multi-Housing Association leases is that because they're used throughout the state with regards to for landlords, big landlords that own thousands of units, these have been to courts throughout many different jurisdictions. They usually go to family court, is where you would do your eviction, and so the judges are familiar with those leases. Now, that isn't the only lease that you can get. You can find some other ones, but you don't want to be in violation of the Plain Language Act or have something that goes against one of the statutes. So make sure wherever you go with regards to getting the leases that they're compliant. So that being said, the other thing you want to do is check with each individual city. So again, if you own property in Minneapolis, we've talked a little bit about this before, that Minneapolis has a whole bunch of overlays that are in addition to what the state rules are. And you'd want to make sure that you're compliant with those as well, how you're running your business. So if you are going to buy in Minneapolis, go out to their website, go to 311, call 311, go out to the website and look up and download the rules so that you are acting appropriately. They're a big city. They have tons of people in the enforcement division, and everybody wants to do the business correctly. Make sure that you are, and the resources are there for you to provide. And ignorance of the law would not be a defense. So it's available to you. You need to make sure that you understand that. Okay, that being said, you are allowed to screen your tenants on various criteria, and you have to have a general set of criteria that you're going to utilize when you're running your rental business so that everybody knows how you're going to make your tenant criteria selection. Now, Minneapolis, with some of their rules, has gone a step beyond and have limited what you can and can't do based on somebody's criminal and credit past. And rather than go into all the minutia specific to Minneapolis, I'm just going to again say go out to Minneapolis to their website and make sure that you have read and downloaded all of the rules so that you know what to do if you're owning property in that city. Now, other cities may have something as well that I'm not aware of, and it could happen at any given time. So just double check, always go out and double check. There are various rental services that you can utilize. TransUnion's My Smart Move, I think, is one of the best, but that's just my personal opinion. The reason I like them is that you are not touching somebody's social security number, and therefore you aren't responsible for it, whereas otherwise you might be, for identity theft or something. Instead, what you do is you register over at My Smart Move, you create a landlord account, you give that link to your potential tenant. Your tenant goes on then and pays with their credit card at My Smart Move, and then you're sent a copy of the report, and the report goes over the criminal credit, unlawful detainer history, and that comes back to you also with a recommendation from TransUnion that you can override, but based on what they see, things that you might want to either ask for more explanation of, or maybe even not proceed with if they, if the computer algorithm identifies it as such. So come up with your list of criteria, make sure it's non-discriminatory, and then go ahead and sign up with a service like My Smart Move or My Smart Move itself. That's what I would recommend that you consider doing. Let's see here. Now, smokers, at least as of right now, are not a protected class, and neither are pets in most circumstances unless they're a service animal. So smokers, you can have a non-smoking building if that's your policy, non-smoking. And one thing about that is that you are probably a non-smoker yourself, and you know what it smells like when you go into a building that somebody has been smoking in. It's not something that you want to be in very long. So if a tenant of yours has smoked quite a bit or smoked at all and left their residual smells in that property, then you're going to be having to de-smoke it, if you will, and that's expensive. And then the question would be as well, who's responsible for the cost of, maybe repainting with Kills or TSP, to remove the nicotine, and or replacing draperies, blinds, carpeting, and all of the above could occur. Could be very expensive to remove smoke from a property, maybe $4,000 to $8,000, I guess, even maybe more, maybe a little less, depends on what you have to do. So I would recommend that you consider having a non-smoking unit, but that's up to you. And then there are non-smoking addendums that you can have attached to your property, where everybody is in agreement that smoking will not occur in that property. That would be one thing. Now, with regards to pets, unless somebody has a doctor service pet signed release, that they need that for a service animal, you may, and I say may because I'm going to tell you to go talk to your attorney, you may not have to rent to them unless they have that letter. Now, people can go online onto the internet and download a service animal release and fill it out and sign it. I don't know that that qualifies. It's a non-doctor release. So I'm just going to say if somebody has a pet and you have a non-pet policy that may be in conflict with that, you may need to seek your attorney's advice on how to proceed. Might be a little more complicated as well if you have a condo townhouse and the person brings a service animal and the association has a policy against animals or certain size animals, and that particular animal that they want to bring in is in conflict with that. I would say that, again, you need to talk to your attorney, but you may need to speak to the board and ask for an accommodation, and that may be what you're required to do. And if the board denies it, I mean, they don't have to rewrite their whole association rules, regs, and bylaws. So that would be up to them to decide how they want to deal with a special accommodation request. So it gets a little more complicated, in that situation. I haven't personally been involved in that, so can't give you direct firsthand experience, but you could hypothetically think it through and see that there could be potentially a problem. So, but if they're not protected with the service animal, My non-legal opinion is that you don't have to rent to them because they're not a protected class. Animals, that is. How long do you write your lease? Well, if you have a condo or townhouse, you may be required to write that lease for a minimum of a year. You're going to want to check your rules, regs, and bylaws and see what they require. And most, if not all, will prohibit Airbnbs or short-term rentals. Again, they're looking for stability in their housing, and they don't want to turn into a revolving door with lots of different people, that are short-term tenants. So you need to always, the rules and regs and bylaws always supersede your business, because that's how you're engaging in the business under those rules. So make sure that you understand those rules and abide by them, versus saying, well, I don't care, I'm going to do it anyway. Well, then they have the right to come after you because you're in violation of those rules. So during that initial 10-day review period, when you have them, when you purchased your unit, make sure that you understand the length of the lease and the tenancy, how that'll be dealt with, the proper notices. Many of the associations require that you provide the association with a copy of that lease for their records. They also want to know the name of the tenant, the name of their car. They may want a copy of a renter's policy, and or the fact that you've done a criminal credit background check and a drug-free addendum. So there's different forms or requirements that the association may overlay upon you that you wouldn't necessarily have. At least you might not have all of them if you owned a single family home or a duplex or triplex. So again, the rules, regs, and bylaws have to be provided to your tenants so that they know how to live their life accordingly in that project. So once you buy it, you're going to have the copy, and then when you're going to give that copy to your tenant, and you probably want to provide that at the time of the pre-lease so that they can read it and understand what they're going to be entering into. And then if they pass your screening, then you can enter into a lease with them and all is good. With regards to notice period, typically a lease without a notice period will roll over at a 30-day month-to-month. You don't get to have necessarily a holdover clause where it continues for perpetuity. If it isn't rewritten, or you don't give a 60-day notice to somebody, then you can't maintain it for 60 days at the end of the lease. So if you have a 60-day notice, you need to, instead of a 30, for example, you need to make sure that you've given them written and verbal notification that the lease is ending during that time period. I think 60 days is nice because it gives you more opportunity to decide what you're going to do, either market it or to sell it, or whatever your plans are. 60, I think, is a little better than 30. So check your lease, check the statutes, make sure you're doing things compliantly. With regards to damage deposits, there is no magic other than if you make it too high, then what might happen is that the tenant won't be a tenant, they'll be a homeowner. The reason most tenants are because they don't have money for a down payment. Now, what many of the tenants don't know is that there are programs out there today that allow you to purchase a home with as little as $1,000 down, and you can borrow money to cover the down payment and the closing costs, depending on your income and your credit. So that's out there, but most tenants don't know that, or they just want to be tenants for a while before they become homeowners, maybe because of a job, or they're not sure exactly what they're going to do in their life. So not every tenant is a tenant because they can't afford it, but many of the tenants that can't afford it probably could afford it if they knew of all the different programs. So if you have the damage deposit too high, you're going to eliminate some of your tenant pool. I've found a good number is usually equal to the first month's rent. So if your rent is $1,500 and you made the damage deposit $1,500, that would be something that I would say most tenants could cover. You would, if you chose, be able to go ahead and stagger how you received it. So if you had a really good tenant that was a little short of money, you could, if you wanted to work with them a little bit, you could say, okay, well, you can give me $500 this month, $500 next, and $500 the next, until they built up that $1,500 damage deposit. So just another way, there's no hard and stone rules, but it's whatever you feel will work for you and your business model. One of the things that you want to avoid, both from your perspective and also the tenants, is an unlawful detainer and an eviction. I think a lot more can be accomplished with dialogue and maybe a mutual understanding than having to bring in the court system and go to family court and file to get rid of somebody. So basically, if you don't pay, you don't get to stay. And we've had COVID, and then there were some moratoriums on that. Some tenants really could pay, and they took advantage of that anyway, and the landlord didn't get paid, and that's a risk until the laws are changed. That's the way that is. There's no ability necessarily to recover that money until after they've left, and you may be able to pursue them through some of the court actions. But again, I think if you have a good relationship with your tenant, and you speak to them in terms of fairness, if they can't pay, then let them out of their lease, let them move on into somebody else's house or couch or wherever they may be going. But it will be the kiss of death for them if they get an unlawful detainer on their record from landlords that check. So a landlord, when they do their screening, if they see an unlawful detainer, they'll generally run, unless it's from a long time ago and there's a reason why that occurred. But if it's just because I didn't want to pay and the landlord had to kick me out, that sounds like trouble. And so that would be grounds possibly for a denial if your policy allows for no unlawful detainers. Now, again, go back to Minneapolis, they're always changing the rules on what you can and can't do, so you may be prohibited from doing some of those things within the city of Minneapolis. So just, if you're going to buy in that city, make sure you check the rules and compare that against your current set of how you want to run your business, because that is going to be impacted. But like I say, evictions won't work for anybody. What happens is you go to family court, you get your day in court, the tenant shows up or they don't show up. If they don't show up, you win. If they do show up, then the judge may grant them a limited amount of time before they have to leave. If they don't show up, again, then they're still in possession of your property. Then you have to go to the sheriff's office. You have to pay the sheriff to come over and be there when they do the eviction. And then you have to do an inventory of their items that they've left behind. And then you have to store it. And then you have to give them notice to come pick it up and pay your reasonable storage cost. So it's just something, that if you can avoid, even at a slight minimal loss, that might be more beneficial so that you can move on with your life than pursuing them. That's what I would say, is try to work it out. Most people are reasonable. Hopefully your tenant, if you ever get in that position, will be reasonable. I'll tell you that my experience in that area is very, very, very limited, knock on wood. I've had mostly good tenants. If not, I'm going to say 99% of them have been great people. There's that 1%. If you do it long enough, you're going to run into somebody that didn't treat your property the way they should have, or didn't pay like they're supposed to. But most people are good people and want to do the right thing. And if you provide good housing and are respectful to people will generally return in kind the way that you treat them. Which is, again, why we go back to, they're a client of yours. You're providing housing, they're your client. Give them something that they want to be proud of and want to maintain. If you put them in a situation where you're not fixing things and not maintaining the property or giving them a hunk of junk, then they're going to treat it that way and treat you in kind. So I've always lived by the golden rule, and it served me well. I would encourage you to run your business that way too, your landlording business. With regards to insurance, so I'm a big fan of talking with a knowledgeable insurance agent about appropriate forms of coverage. Now, this would probably be your property casualty person, could be or it could be an insurance broker. It might be your local guy, could be your farmer's guy, for example. Farmers, as an endorsement, happens to be, I think, a wonderful company, and they get it. A lot of the other companies don't, meaning they don't want to be in the landlording business, providing business owner policies, umbrellas where the liability extends to multiple properties. And it really does make a difference, not only in company though, but also with the agent. The right agent will read the master hazard policy that accompanies the condo townhouse, and then help you design your business owner's policy accordingly, so that you cover the deductible gap. So for example, if there's a big master hazard policy on the complex, let's say a tornado comes through and blows it over. Well, then that property will be rebuilt, but there will be a deductible. Many of them today are up to $25,000. So that's a big number that you might have to pay out of pocket. But if you had a business owner's policy and that had coverage in there for that $25,000 deductible, then it would be the insurance company, your insurance company, that would pay the deductible on the master hazard while yours is being rebuilt. With regards to a business owner's policy, because your landlording is a business, you get protection under many policies for lost rents. Now, lost rents means if that tornado came through and now you don't have the ability to get rent because the building isn't rentable, then they will pay you the rent that you would have received so that you can continue to make your mortgage payment, because the mortgage doesn't go away if a natural catastrophe occurs. You still have to make that payment, but then you don't have the rent coming in, which means you're digging out of pocket, unless you have, again, a business owner's policy that covers you for those lost rents. Same with liability. A business owner's policy will typically have another layer of liability coverage for you in addition to the baseline. Hopefully your tenants, and I request that my tenants carry a tenant's policy. So hopefully they have some liability in place if something happens over there, and then you have coverage over and above that through your business owner's policy. Your business owner's policy also may cover you for vandalism. So if somebody leaves on the way out for whatever reason and decides to trash your place, that you'd be able to make a claim for that under your business owner's policy. Again, make sure that those types of coverage, liability, lost rents, and vandalism, are covered. And if your insurance carrier doesn't, then maybe you need to talk to another insurance carrier. If your insurance agent doesn't understand rentals and master hazard policies and the need to dovetail the deductibles, you need to find another insurance agent. With regards to an umbrella policy provides a blanket of liability over and above your baseline liability. A very common number that people will get is $1 million. $1 million of excess liability covers you after your policy is kicked in. Normally it's not in addition to, it's $1 million plus, but again, check with your company, see how they're dealing with that. And it's very inexpensive in the sense that to get $1 million of coverage is usually right around the 300-ish figure. So that means that your liability extends that extra $1 million of coverage to your home, your auto, your rental property, your boat, your snowmobile, basically all of your life. Now that's assuming that you did nothing criminally and you weren't criminally liable, because then you don't get protection, of course. But assuming that you were doing business the right way and somebody sues you, then you have that protection. So an umbrella is something, even if you choose not to get rental property, I would say it might be something that you have that discussion with your insurance agent. And it's cheaper by the dozen. So if you get $2 million, for example, it isn't double. It might be 1 3/4 the cost. And if you get $3 million, it might be 1 5/8 of the cost. So it's not, or that'd be like 2 5/8. So it's cheaper by the dozen. So that's how insurance is typically written. The more you get, the cheaper it becomes. So if you think that you're going to build quite a portfolio someday, or you feel like you're going to have a large inheritance someday, or of your own makings, you're going to have quite a bit of money, you may want to protect your future earnings in the sense of having a decent amount of insurance through liability, so that if somebody does decide to sue you, that there's at least somewhat of a firewall between you and your assets, and that would be the insurance policy. Some people say, well, you know what, I'll just buy property in an LLC, and then therefore I don't need insurance. Well, I'm going to defer you again to your attorney on whether or not you think that's a good idea. I will tell you that Fannie and Freddie, when they lend money, they lend them to individuals. They don't lend them to LLCs. So if you want to go to a bank and get a 30-year fixed Fannie or Freddie investor loan, it has to be in your name. If you go to the bank and you want to get a commercial loan, that can be in an LLC, but you have a personal guarantee typically on those types of products. Whether or not that LLC provides you your protection that you're looking for, I'm going to say to a large extent depends on how you run your LLC. Are you really an LLC? Meaning, are you commingling monies from the LLC checkbook to yours? Are you having an annual member meeting? Are you documenting it in a book of minutes? Are you really an entity, or are you an entity on paper that can be pierced, and they can, an attorney in court could pierce that veil of protection and come at you because you weren't really an entity, you were really a sole proprietor. That's going to be, I'm going to say, the angle that might be taken as they proceed with a suit against you, is that you really weren't this entity, so the protection that you think that you have might not really be the protection that you hoped that you had, which is why the insurance might be a nice augment to that, or it just might be the way that you run it is just with the insurance. But again, entity creation, talk to your attorney, talk to your accountant, see what works best for you and your situation. If you have a partnership with somebody, that may entail the creation of an entity more so than if you are an individual. But again, that's not for me to say how you should do that. Okay, another thing, if you're buying a foreclosure, and we talked earlier that buying a foreclosure is probably going to be, the opportunity to do so is going to be very limited because there just aren't very many foreclosures for investors today. But one of the things when you buy them, you typically get no disclosures because the bank foreclosed on it. They never lived there. They can't tell you anything about it. So it's kind of caveat emptor, buyer beware, do your due diligence, do your testing and checking to the extent that you're allowed. Most purchase agreements from the banks will allow you a certain amount of time to do your tests, go forward, or forever hold your peace. One of the things that your insurance agent might be able to obtain for you, not all agents and companies can do this, but there's something called a clue report, which is a report like a credit report, but it's for properties. So every property has a comprehensive loss report, and it shows if there was ever a claim for, let's say, a roof or siding. So let's say, for example, the former owner that was foreclosed on made a roof claim and received, $10,000 and put it in their pocket. They could do that. They don't have to replace the roof, but then they get foreclosed on, and your new insurance company finds through their underwriting process 30 days after closing that, hey, you know what, that roof failed. That roof should have been replaced. They can cancel your policy and say, hey, you know what, you got to put a new roof on because that other one is leaking and bad, and we're not going to pay twice because the other company already paid for it to be replaced and the guy just kept the money. So a clue report, if you can obtain it or your agent can obtain it, might be valuable on a distressed foreclosed property where you don't have any information and you've got to just do it through your due diligence. And so that's sort of my take on insurance, is find the right agent. It really, really makes a difference. I can't stress that part enough. I love my agent and I would be happy to share his information with you, but there are competent agents and there are incompetent agents, and it really makes a big difference. Okay, well, I hope you've enjoyed this class. If I can help, my name is John Mazzara. I'm available at 612-386-7027. You can email me at john@johnmazzara.com. And you can go out to my RE/MAX website at www.minneapolis-stpaulhomes.com. And if I can help, I'd love to. I'd love to shake your hand someday and call you a friend. Have a wonderful day and good luck.